Hey guys and gals, this is the BarExamandChill podcast. I'm your host TJ, and today I'm going over a February 2013 UBE MEE question that covers civil procedure. It goes through the differences between issue and claim preclusion. Typically, I just want to jump right into the hypo and then do the analysis for maximum re-listenability. But today I just want to hop in and do a little quick check-in with everybody and also describe kind of my vision for the show and what's available on the Patreon and how I think about that and everything. So basically, when I was studying for the bar exam to take the UBE, I didn't want to pay for a prep course, so I just self-studied. And I was really looking for somebody to do what I'm doing, just read me the actual bar exam so that I can issue spot through the audio. I mean, I can just listen to somebody read the hypo, and then you can kind of issue spot as somebody's reading it, and then just kind of lead me through it and really try and focus on the rule statements that you're supposed to know. Ultimately, you got to memorize all of the rule statements for the bar exam and make sure that you have them in your Rolodex so you can kind of flip them out and get the wording down for the test takers, for the test graders, so they can see that you know all the stuff you're supposed to know, and then apply it on the exam. So that's kind of what I was hoping to create, was just what I was looking for. Just somebody that would come on, read the hypo, and then go through it and give me the rule statements I'm responsible for knowing. So I've been doing that on this podcast, and I've been doing that with the 7 MBE topics. And I figured, okay, well, I'll cover everything else on the Patreon, which will be paid. And so on my Patreon, you got 2 tiers. One for you get all the audio lectures. I do everything outside the 7 MBE topics. And then also a second tier above that, which you get access to posts. And also I have 2 full outlines. So when I was going through to study for the bar, I created a full comprehensive outline as I was going through to actually review myself for every topic. And for the UBE, I just used that, and that's actually available for sale individually. You don't have to sign up for a subscription or anything. You just buy the outline. But if you buy the second tier or whatever, the higher tier on the Patreon, you get access to the outlines, which are comprehensive. It's 75 or 80 pages. It goes through every topic for the bar exam. And I also, created one for California, which tests all the same things for the MBE, but has different essay topics that they cover and California specific portions of the law that you're responsible for knowing. For instance, there's federal evidence, but you also have to know California evidence and so on. So I've got 2, outlines, one for UBE, one for California. You can get those on the Patreon without having to subscribe or anything. But my initial thinking was, hey, on the Patreon, I'll just go through all the other essay sections that are outside these MBE topics. But I've got a subscriber, and they were requesting some lectures on various topics that they're struggling with. And actually, for appointments and removals, there's not a hypo for an MEE. They haven't tested that on the essay section. So if somebody wanted help with hey, I'm having issues understanding kind of the nuances here with appointments and removal, which, they just overturned Humphrey's executor in this Trump v. Slaughter decision. So I don't think that they would probably test that on the essays. Doesn't seem very essay compatible, because IRAC an appointments clause issue, it's going to be can the president do that? No. That seems a little bit not what they're seeking to do in the essay sections, but you never know. They could test separation of powers and they could throw it on there, or it could just be a quick sub question in an essay. You're responsible for knowing separation of powers, and it's on the MEE or whatever for the bar exam. But I can't find an actual hypo that tests that, right? So if I was going to do, if I was going to teach that, I couldn't do it through the essays really. So I figured, okay, well, maybe I could just do a lecture on the appointments power. So that's kind of what I'm thinking is on the Patreon, I'll do by the way, for the UBE, they've gotten rid of, in a lot of, every jurisdiction's rolling this out at a different timeline. So some states are getting rid of some of the essay topics later. Some of them, it's this next upcoming bar exam. They're getting rid of secured transactions and trusts and estates and all that stuff. So you're really on this new streamlined bar exam for the UBE. They're really only testing the 7 MBE topics plus business associations, and they kind of got rid of everything else. So on the Patreon, it doesn't really make sense to just have business associations only for the UBE. If you're buying the audio lectures at the first tier, then like really you're just buying business associations for your UBE. I've got like lectures on the Patreon for community property and California specific stuff, but for the UBE, it makes somewhat less sense because there's only one topic outside the MBE that you're being responsible for testing, which is business associations. So I figured, for the people that are currently subscribed, I'm going through my own little journey with the bureaucracy of getting into this new jurisdiction. So at least until this upcoming July bar exam, if you come onto the Patreon and you pay for a subscription, I'll just take recommendations and try and do lectures outside of just reading the hypo and going through and answering it and doing all the rules and stuff, which I'm doing here for free, right, for the MBE topics. But for the Patreon, I'll do outside the MBE topics. Then I can't promise, I'll get to every single recommendation, but or every single request. But if you subscribe, basically you just get at me. There's an email through the Patreon. By the way, I set up a subreddit. So if you go to BarExamandChill subreddit, you can also just kind of like give me, interact with me, give me stuff that you're struggling with. I can interact with you there and try and answer questions or whatever. But anyways, going forward, I guess if you're UBE, if you want to subscribe to the Patreon, at least until this July bar exam, I'll take requests and try and throw together lectures where I think, I'll have discretion to kind of look and figure out what are high yield topics, and maybe I'll give some lectures there outside of just reading the hypo. But that's what I'm going to do here for this free podcast. This is what I was seeking when I was studying. I was self-studying, and I wanted somebody to just read in a podcast form the actual bar exam so I could listen, issue spot myself, and then go through and explain and then review those rule statements. So that's what I'm going to be doing here. If you go to the Patreon, like I said, there's two tiers. My original thinking was I'll do all the topics outside the MBE and find hypos and so on and go through them just like I do here. But on the Patreon, you've got two tiers: the audio lecture for all audio lectures, and then just everything. But like I said, for the UBE, it somewhat makes less sense now because since they've streamlined it, there's only business associations. So if you sign up for the Patreon, shoot me some messages. I'll try and throw together some lectures. That's for, people that want to pay. But, it's not a full bar prep cost, right? I mean, my outlines are cheap. If you go to like some bar prep organization, they'll charge you like hundreds of dollars or whatever for like one of these comprehensive outlines. I think I'm selling it for like $30. It's somewhere around there. So it's a lot cheaper, but I passed the bar exam with my outline. I got a 290 on the, I think it was, is that the correct number? Anyways, it was enough to pass in every jurisdiction. And it was an outline that I used for myself to pass the bar exam. That's comprehensive. And so all the subjects are kind of broken down in outline format, like you'll be familiar with black letter law and application and so on. Those outlines are available. But I do these lectures similarly there. And like I said, if you sign up or if you have signed up, just get at me and give me some stuff you're struggling with. I'll try and throw together some lectures and interact with you there. Obviously, I'm going to prioritize and interact with people that are paying first. But, let's jump into this hypo. Let's get into it. So that's that. That's, I'm not going to do that every episode. Just checking in with you guys. That's kind of how I'm thinking about the show. And I'll keep doing these MBE lectures here on this podcast for free. And keep, like I said, you just want to read the essay, maximum listenability, go through, give you your rule statements, and and that's what I was looking for when I was studying for the bar exam, is like a supplement to putting in all those hours yourself of having to go through. And, if you're using AI, you can go in and say, hey, give me 20 MBE questions on X subject, make them hard, test the exceptions to the rule, give me, give me some MBE questions that test the high yield rules and contracts or whatever. And it's not going to be quite as good as like a prep org, but it's still enough. For me, at least, it was enough for me to pass. So if you're out there in the wilderness doing this stuff on your own, I think this is a good supplement. A lot of this stuff is pretty helpful. I don't think it's, you're going to have to do the grunt work and the legwork yourself if you're self-studying like I did. But at least this will provide some structure and hopefully will be useful. Okay, let's get into the February 2013 Civil Procedure MEE. This is the UBE, but this is Civil Procedure, Federal Civil Procedure, so you're responsible for knowing this on the California bar exam as well. Let's jump right in. Here's the hypo. Mother and son, who are both adults, are citizens and residents of State A. Mother owned an expensive luxury car valued in excess of $100,000. Son borrowed mother's car to drive to a store in State A. As son approached a traffic light that had just turned yellow, he carefully braked and brought the car to a complete stop. Driver, who was following immediately behind him, failed to stop and rear-ended mother's car, which was damaged beyond repair. Son was seriously injured. Driver is a citizen of State B. Son sued driver in the United States District Court for the District of State A, alleging that she was negligent in the operation of her vehicle. Son sought damages in excess of $75,000 for his personal injuries, exclusive of costs and interests. In her answer, driver alleged that son was contributorily negligent in the operation of mother's car. She further alleged that the brake lights on mother's car were burned out and that mother's negligent failure to properly maintain the car was a contributing cause of the accident. Following a trial on the merits in son's case against driver, the jury answered the following special interrogatories. Do you find that driver was negligent in the operation of her vehicle? Yes. Do you find that son was negligent in the operation of mother's car? No. Do you find that mother negligently failed to ensure that the brake lights on her car were in proper working order? Yes. The judge then entered a judgment in favor of son against driver. Driver did not appeal. 2 months later, mother sued driver in the United States District Court for the District of State A, alleging that driver's negligence in the operation of her vehicle destroyed mother's luxury car. Mother sought damages in excess of $75,000, exclusive of costs and interests. State A follows the same preclusion principles that federal courts follow in federal question cases. Question 1. Is mother's claim against driver barred by the judgment in Son v. Driver? Explain. 2. Does the jury's conclusion in Son v. Driver that mother had negligently failed to maintain the brake lights on her car preclude mother from litigating that issue in her subsequent suit against driver? Explain. Awesome. So let's get into our preclusion doctrines here. I'll just kind of outline this first a little bit differently, I guess, than some of the other lectures. I'm just going to go through the differences between claim preclusion and issue preclusion before we jump into our IRAC. So bar examiners, they love testing preclusion, right? Because it forces you to distinguish between blocking an entire lawsuit, that's going to be your claim preclusion, versus blocking a specific fact or argument, that's going to be your issue preclusion. So claim preclusion is just your standard res judicata. Our core concept here is that you only get one bite at the apple to litigate a claim, right? If it applies, it completely bars an entire subsequent lawsuit. So that's claim preclusion's core concepts. You've got 3 elements in your rule statement here. 3 things you need for claim preclusion. 1, it has to be the same parties. So the second suit must be between the exact same parties or those in privity with them as the first suit, and they must be in the same configuration, same plaintiff versus same defendant. Not always, but generally speaking, that's the case. So requisite 2, you've got to have a final judgment on the merits. So number 1, same parties, could be, in privity. That's the tricky part there, but it has to be the same parties or they have to be like directly in privity. Number 2, final judgment on the merits. The first suit must have concluded with a valid final judgment on the merits. So you've got to know about a final judgment on the merits. This is applicable in, multiple contexts on the bar, but on the merits includes jury verdicts, summary judgments, directed verdicts, and default judgments or dismissals with prejudice, right? For instance, for failure to state a claim under 12b-6. Those are on the merits. If it gets rid of the whole lawsuit, basically, right? If you have a jury verdict, or it doesn't get rid of the whole lawsuit, but it adjudicates like on the merits of the claim. I mean, I guess that's just restating judgment on the merits, but really it's like if it's actually litigated to its completion, right? So if it goes all the way through trial and there's a jury verdict, or a judge gets rid of it at summary judgment, or there's a directed verdict or default judgment, somebody failed to answer, in which case everything gets like judged against them if they meet those prerequisites, or a dismissal with prejudice, right? Because that gets rid of the lawsuit. So not on the merits would include stuff like dismissals for lack of jurisdiction, right? If this was like a subject matter jurisdiction issue or personal jurisdiction issue, improper venue, failure to join an indispensable party under Rule 19. These are not on the merits, right? There's somewhat more procedural reasons why the lawsuit is not proceeding, or here, I guess, if there's a dismissal for lack of jurisdiction, right, you might be able to bring the lawsuit again just in the proper venue or in the proper jurisdiction. All right, so 1, same parties. 2, final judgment on the merits. 3, same claim or cause of action. So those are your 3 things, right? So let's talk about same claim, cause of action. Under the modern federal transactional approach, the second suit is barred if it arises out of the same transaction, occurrence, or series of connected transactions as the first suit, right? Because you have those compulsory claims that you have to bring. If it's in the same transaction or occurrence, they want everything to be brought in the same lawsuit. So our 3 rule elements for claim preclusion are same parties, 2, final judgment on the merits, 3, same claims or causes of action. Let's talk about some common bar exam traps here. Claim splitting. So a single plaintiff cannot sue for personal injuries from a car accident in suit 1 and then file a separate lawsuit against the same defendant for property damage from the exact same accident in suit 2. Right? I mean, this kind of makes sense. They don't want you to just be able to harass somebody by filing, like, if, for instance, if you had 10 causes of action, 10 different lawsuits, then I guess strategically somebody can try and drive your costs up by forcing you to defend multiple lawsuits. The court wants everything from the same transaction or occurrence to be litigated in the same matter, and that makes sense. So another common bar trap here, privity constraints. So close relationships, like, for instance, if it's a parent-child, spouse, or employer-employee, they don't automatically create privity for claim preclusion if the individuals are suing for their own distinct separate harms. That's something to keep in mind here. Let's talk about issue preclusion. So claim preclusion, you want to keep in your mind 1, 2, 3, same parties, final judgment on the merits, same claims or causes of action. Number 2, let's get into issue preclusion. Our core concept here is this prevents the relitigation of a specific factual or legal issue that was already fought out and decided in the prior case. So somebody litigates, they have like they have a finding of negligence. Can you have in a separate lawsuit issue preclusion, basically saying you can't relitigate this issue of negligence? If you're found negligent in the first case, can you just say, hey, in the second lawsuit, we don't have to relitigate whether they were negligent or not. It was already found in this first suit. That's what we're talking about. So the second lawsuit itself is allowed to proceed, right? But the specific issue is locked. So, for instance, as we just discussed, perhaps, it would be able to proceed. The lawsuit itself would be able to proceed, but you're not going to litigate negligence again. Okay, so we've got 4 elements for our rule statement here. If you have issue preclusion, you need 4 things. Number 1, same issue. It has to be the exact same issue of fact or law, and it must be involved in both actions, right? Number 2, it has to be actually litigated and determined. So it has to be that in the first lawsuit there was an actual conclusion reached. The issue must have been actively litigated and formally decided in the first action. There has to have been like a conclusion, right? Number 3, it has to be essential to the judgment. The determination of the issue must have been necessary and essential to the ultimate judgment in the first case. If the winning party would have won anyway, regardless of how that specific issue turned out, it was not essential. So it has to be something that was essential in the first litigation. Number 4, against a party to the first suit. Issue preclusion can only be asserted against a person who was a party or in privity with a party to the first lawsuit. So this is a constitutional due process requirement. Everyone gets their own day in court, right? All right, so issue preclusion, you got these 4 rules, the 4 requirements. 1, same issue. 2, actually litigated. 3, essential to the judgment. 4, against the party to the first suit. Awesome. Let's talk about mutuality versus non-mutuality. This is, I guess kind of a distractor here. So under the traditional rule, mutuality, only a party to the first suit could use issue preclusion. Has to be a party to the first suit. Number 2, you've got this modern federal rule of non-mutuality. A non-party to the first suit can use issue preclusion against someone who was a party to the first suit in 2 main circumstances, right? Defensive non-mutual. A new defendant uses a prior finding to shield themselves from liability against a plaintiff who already lost on that issue in suit 1. And offensive non-mutual. A new plaintiff uses a prior finding to establish liability against a defendant who already lost on that issue in suit 1. Courts apply strictly and look at fairness here, right? So could the plaintiff have easily joined the first suit? Was the defendant incentivized to vigorously defend? You're going to have all these kind of inquiries into that. Let's jump in. We've got kind of our top line overview of claim preclusion and issue preclusion. Let's bring this into our hypo that we read. So we've got our UBE February 2013 hypo that we read. Our first question was, is mother's claim against driver barred by the judgment in Son v. Driver? So our issue here is mother's property damage claim against driver barred under the doctrine of claim preclusion, res judicata, by the final judgment obtained by Son in the prior personal injury lawsuit? Our rule here, again, we'll kind of restate our rule in the current context. Under federal preclusion principles, claim preclusion prevents a party from relitigating a claim that was or could have been litigated in a prior action. Claim preclusion requires 3 elements. 1, both suits must involve the same parties or their privies. 2, the first suit must have concluded with a valid final judgment on the merits. And 3, the subsequent claim must arise out of the same transaction or occurrence as the initial claim. Crucially, a non-party to the first action cannot be barred by claim preclusion unless they are in privity with a party to that action. Privity, and this is where we'll try and define what privity is, privity exists only in limited circumstances, such as where the non-party's interests were adequately represented by a proxy, where the non-party controlled the prior litigation, or where there is a substantive legal relationship, for instance, successive property owners. A familial relationship, parent and child, or a simple bailment relationship, lending a vehicle, does not establish privity for claim preclusion purposes. So there's our top line rule here. We got our requisites for claim preclusion. What are the elements we have to meet? Well, 1, 2, 3, we've got those, and let's apply them to our facts in the hypo. Well, is this a final judgment on the merits? The judgment in Son v. Driver was entered by a federal judge following a full jury trial on the merits, and Driver did not appeal. Thus, a final judgment on the merits exists. Nice. So is there final judgment? Yeah, they went all the way through trial, and there was a verdict. So, boom, final judgment on the merits. Same transaction or occurrence? Well, both lawsuits arise out of the exact same auto accident involving driver rear-ending mother's luxury car. Great. And then same parties or privity. Here's where the element may fail, right? So mother was not a party to the first lawsuit. Only Son sued driver. Furthermore, mother is not in privity with Son. Although they are related, right, and Son was driving mother's car, their legal claims are entirely distinct. Son sued for his own personal injuries, whereas mother is suing for property damage to an asset she exclusively owned. Son did not represent mother's property interests in the first suit, and mother had no operational control over Son's litigation. So because mother is a separate plaintiff with a separate legal right, who was neither a party nor a privy in the first action, she cannot be bound by it. So our conclusion here is just simply going to be mother's claim against driver is not barred by claim preclusion because mother was neither a party nor in privity with a party to the first action. So here again, there's going to be differences. I think even on the sample answers, you see that people come to like different conclusions sometimes. In the hypos, it might be pretty close. Again, your most critical thing that you want to do on the bar exam is just make sure that you're hitting like the actual, issue, rule, application, conclusion, right? I mean, I think if you're making a conclusion that other people disagree with, it's probably fine as long as you're just going through the analysis. So I didn't think of this as a creative writing exam. I literally just said, the issue here is blah, 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 and then state the rule statement. That's the stuff you have to have memorized, and then apply it to the facts. And you want to take exactly quotes from the actual hypo you're given. Here, the hypo says quote, and then just type in what the hypo says. So therefore, apply the rule. Here's what's going to happen. As long as you're going through that, you're going to be getting points. Make sure you're making in your essays everything clear to the extent possible with headers, and you want to bold like keywords and phrases. So for instance here, right, claim preclusion. Number one, you might want to have a header, just, hey, claim preclusion. Is mother's claim barred? Well, here's your rules, and let's apply it to the facts, reach your conclusion. Let's get into question 2. Does the jury's conclusion in Sun v. Driver that mother had negligently failed to maintain the brake lights on her car preclude mother from litigating that issue in her subsequent suit against Driver? So our issue, does the doctrine of issue preclusion, which is also referred to as collateral estoppel, preclude a non-party plaintiff, here your mother, from relitigating an adverse factual finding made by a jury in a prior action to which she was not a party? And then we'll go into our rule, right? So our rule statement that we're going to try and put down on the test here: issue preclusion prevents the relitigation of a specific factual or legal issue that was already decided in a previous case. For issue preclusion to apply, you've got to have 4 elements. Those are: number 1, issue in the second lawsuit must be identical to the issue in the first lawsuit. 2, the issue must have been actually litigated and determined in the first suit. 3, the determination of the issue must have been essential to the judgment of the first suit. And 4, the party against whom preclusion is being asserted must have been a party or in privity with a party to the first suit. Under the Due Process Clause of the U.S. Constitution, a court cannot bind a person to an adverse factual finding if that person was never given a day in court to litigate the matter. Therefore, issue preclusion can never be used against a non-party who lacked full opportunity and incentive to defend or litigate the issue in the initial action. Here, we'll just add here, additionally, a finding is essential to the judgment only if the ultimate outcome of the case depended on that finding. If the judgment would stand unchanged, regardless of how that particular issue was decided, the issue is not essential. Let's apply our rules here to our facts. Is it against a party or privy? Well, Driver is attempting to use issue preclusion against mother, right? As established in the claim preclusion analysis here, mother was a complete non-party to Sun v. Driver and was not in privy with Sun. She had no opportunity to hire counsel, call witnesses, cross-examine Driver's experts, or contest the allegation that her brake lights were out. Therefore, the court's going to say that, binding her to the jury's special interrogatory would violate her due process rights in this second lawsuit. So is it essential? And then secondly, let's apply essential to the judgment. So the finding that mother negligently maintained the brake lights does not seem like it's essential to the final judgment in Sun v. Driver. The jury found that Driver was negligent and that Sun was not negligent because Sun was completely blameless. Driver was fully liable to Sun for his personal injuries. The question of whether mother was separately negligent regarding the vehicle's maintenance had no bearing on Sun's ability to recover against Driver. So because the judgment in favor of Sun stands perfectly intact without the finding against mother, right, her actual maintenance of the car, that finding was a superfluous piece of fact, finding that was not essential to the judgment. So our conclusion here, kind of like the conclusion in the first one, mother is not precluded from litigating the brake light issue because she was not a party or privy to the first action, and finding was not essential to the prior judgment. Nice. So we've got our rules and our applications here for issue and claim preclusion. Hopefully that helps you guys out. If you guys have questions, like I said, I've set up a subreddit, so you can go to BarExamandChill and, leave some comments there, or make a post or whatever floats your boat there. And then if you're on the Patreon, it's easy to contact me. I think you can get in contact, and like I said, if you're paying money and you want help with actual, like you have some recommendations for me as far as like, hey, I need some, give me a lecture on this subject matter, maybe in the Patreon, I'll have the discretion to try and not just do hypos, but just kind of go through outlines and teach subject matter there. So communication is key. Happy studying. Hopefully everybody's feeling comfortable for the bar exam. I know it's coming up. So best of luck and happy studying. Okay, bye.